We often see news coverage of accidents in which someone is injured. Such news stories typically include reports or speculation of lawsuits to come. So it's easy to forget that just because an accident occurs, that doesn't necessarily mean that an injured plaintiff is going to win damages. That lesson was made clear by the Massachusetts Supreme Court in the 1850 case of Brown versus Kendall. George Brown and George Kendall both owned dogs. One day their dogs began to fight each other. Kendall took a long stick and began hitting the dogs to separate them. Brown watched from what he thought was a safe distance. But the dogs moved in his direction, causing Brown to move away from them toward Kendall's back. Kendall didn't see Brown move. Kendall raised his stick again and on his backswing inadvertently hit Brown in the eye. Brown was severely injured. Brown sued Kendall for assault and battery. The trial court judge instructed the jury that if Kendall had a duty to act and was acting in a proper manner, Kendall wasn't liable for Brown's injuries. But if Kendall didn't have a duty to act, then he was liable for Brown's injuries unless he'd exercised extraordinary care. After hearing these instructions, the jury returned a verdict for Brown. Kendall appealed to the Supreme Court of Massachusetts.